you identify yourself for me?
Am I being detained or are you just asking questions?
What are you doing here? Do you live at this residence?
This is my property. What legal reason do you have to be here?
The air inside the unmarked fleet sedan was thick, smelling of stale black coffee and the oppressive, damp heat of a late August afternoon in the American suburbs. Senior ICE agent Thomas Miller drummed his fingers against the steering wheel, his eyes scanning the quiet, tree-lined street of Oak Ridge Estates. Beside him sat Agent David Evans, a rookie less than 8 months out of the academy, still sweating through his standard-issue polo shirt despite the air conditioning blasting on high. They were hunting a ghost. The file sitting on the center console belonged to a woman named Marisol Diaz, a 45-year-old undocumented immigrant with a final order of removal issued 3 years prior. The tip they had received was flimsy at best. An anonymous call to a regional tip line claiming a woman matching Diaz's description was doing day labor at a house on this specific block. It was the kind of low-priority lead that usually resulted in a drive-by and a dead end. But Miller was facing the end of a long, unproductive quarter. He was tired, he was frustrated, and his judgment was heavily clouded by years of operating in a system that often rewarded aggression over precision. As they crept down the street, the manicured lawns and silent driveways offered no signs of life, save for a single figure working in the front yard of a sprawling 2-story colonial home. The figure was a black woman in her late 50s, wearing a faded, oversized college t-shirt, loose gardening trousers smeared with damp soil, and a wide-brimmed straw hat that cast deep shadows over her face. She was kneeling by a bed of hydrangeas, meticulously pruning the deadheads with a pair of shears. Miller hit the brakes, the sedan coming to a slow, creeping halt by the curb. He squinted through the windshield, his mind immediately leaping across a dangerous chasm of assumptions. He didn't see a homeowner enjoying a Saturday afternoon. He saw the faded clothes, the manual labor, the dirt on her knees, and the color of her skin, and his brain aggressively filtered those details to fit the narrative he wanted. He nudged Evans and pointed toward the yard, stating with unwarranted confidence that they had found their target. Evans looked at the file, noting that Marisol Diaz was of Hispanic descent, roughly 5'2", and a decade younger than the woman in the dirt. Evans hesitated, his voice tight as he pointed out the discrepancies to his senior partner. But Miller waved him off, a dismissive flick of the wrist that carried the weight of 1,000 unchecked biases. He told Evans that people age poorly on the run, that descriptions are always botched, and that she was clearly a hired hand working off the books. It was a textbook example of confirmation bias. Miller had built a conclusion and was now forcing reality to bend to its shape. They stepped out of the vehicle, the humid air hitting them like a physical wall. The heavy thud of the car doors echoing in the quiet neighborhood caused the woman to pause. She didn't jump, she didn't run, and she didn't look panicked. She simply stood up slowly, wiping the dirt from her knees, and watched the 2 men in tactical vests walk up her driveway. Her name was Eleanor Hastings. She was not a day laborer. She was not undocumented. She was an Article III federal judge sitting on the United States Court of Appeals for the circuit, a woman who had spent the last 30 years of her life dismantling complex constitutional arguments and writing opinions that bound the very law enforcement officers currently marching up her driveway. But Miller didn't see a legal scholar. He saw a suspect. As the agents approached, Hastings calmly laid her pruning shears on the edge of a large terracotta planter and crossed her arms. Miller stopped at the base of the 3 concrete steps leading up to her porch. He didn't introduce himself. He didn't explain the nature of their visit. He simply projected his voice with the sharp, commanding bark of a man used to unquestioned compliance, demanding to know her name and asking for her identification. Hastings looked down at them, her expression a mask of practiced neutrality. She did not raise her voice. She did not display anger. She simply asked, in a tone that was quiet but carried the terrifying weight of absolute authority, if they were detaining her. Miller scoffed, glancing back at Evans with a smirk that communicated volumes about his disregard for the woman standing above him. He took a step closer, placing his boot on the first step of the porch, and reiterated his demand, telling her that they were conducting an investigation and she needed to produce papers right now. Hastings held her ground. The porch was her domain, and she knew the parameters of her fortress better than any soldier. She informed them, her voice entirely devoid of intimidation, that she was on her private property, that they had not stated any reasonable, articulable suspicion that she was committing, had committed, or was about to commit a crime, and that unless they possessed a warrant signed by a judge, they needed to step off her property immediately. The legal vocabulary hung in the humid air, sharp and precise. To anyone else, the use of the phrase reasonable, articulable suspicion, the exact legal standard established in the landmark Supreme Court case Terry versus Ohio, would have been a massive, flashing warning sign. It was the language of the courtroom, not the street. But to Miller, wrapped in the impenetrable armor of his own arrogance and systemic bias, it sounded like defiance. He interpreted her constitutional fluency not as a marker of education or status, but as the evasive tactics of someone who had learned how to game the system. He assumed she had been coached. He assumed she was being difficult. This was the critical moment where the trajectory of Miller's career irrevocably snapped. Instead of reassessing the situation, instead of running her plates or checking the address, he allowed his ego to override his training. Miller took the remaining steps, crossing the threshold onto the porch. This was not merely a physical escalation, it was a profound legal failure. The porch of a private home is considered curtilage, an area intimately tied to the home itself and explicitly protected by the Fourth Amendment against unreasonable searches and seizures. Without a warrant, without exigent circumstances like a fleeing suspect or the imminent destruction of evidence, and without her consent, Miller's physical presence on that porch transformed a questionable encounter into an undeniable constitutional violation. Hastings immediately recognized the breach. She took a half-step back, maintaining a safe distance, and stated clearly and unambiguously that he had just violated her Fourth Amendment rights, that he was trespassing on her curtilage without legal justification, and that she was ordering him to leave. Miller's patience, already thin, completely evaporated. He reached out, his hand snapping forward to grab her by the upper arm. The moment his fingers closed around her bicep, he crossed the line from a civil rights violation into a criminal battery and an unlawful arrest. Evans, still standing at the base of the stairs, felt a cold knot of dread form in his stomach. The rookie knew the procedures, he knew the threshold for probable cause, and he knew they didn't have it. But the hierarchy of law enforcement kept his feet planted and his mouth shut, a silent complicity that would ultimately cost him his badge as well. Miller spun Hastings around, kicking her feet apart and forcing her chest against one of the thick wooden pillars supporting the porch roof. He pulled a pair of steel handcuffs from his belt. Even as the cold metal ratcheted tightly around her wrists, biting into her skin, Hastings did not struggle. She did not yell for her neighbors. She let him apply the cuffs, her mind acting as a high-speed stenographer, recording every procedural error, every physical movement, every word spoken. As Miller spun her back around, effectively taking her into custody, she looked him dead in the eye. Her voice remained chillingly steady as she informed him that he was currently effectuating a warrantless arrest lacking any semblance of probable cause, based on a flawed assumption, and that she was not resisting, but she was entirely under duress. Miller mocked her. He laughed a short, breathy laugh, telling her to save the lawyer talk for the detention center, patting her pockets clumsily for a wallet but finding nothing in the loose gardening pants. He grabbed her by the arm and marched her down the driveway, parading a sitting federal judge in handcuffs through her own suburban neighborhood like a trophy. They placed her in the back of the sweltering sedan. The drive to the regional processing facility was agonizingly silent. The heavy plexiglass divider separated the front seats from the back, but it couldn't block the radiating tension. Evans stared out the passenger window, his mind racing through the events on the porch, a growing, sickening realization taking root that they had just stepped off a cliff and were currently in freefall. In the rearview mirror, Miller occasionally glanced at his prisoner. Hastings sat perfectly upright, her posture impeccable despite the awkwardness of the handcuffs securing her arms behind her back. She wasn't crying, she wasn't pleading. She was just looking forward, her face a mask of quiet, calculating resolve. It was a demeanor that finally began to chip away at Miller's confidence. The adrenaline of the confrontation was fading, replaced by a creeping, icy anxiety. When they arrived at the facility, a nondescript concrete building surrounded by high chain-link fences, they pulled into the secure sally port. Miller hauled Hastings out of the back seat and marched her through the heavy steel doors into the harsh, fluorescent glare of the intake room. The room was chaotic, filled with the noise of ringing phones, shouting officers, and the low murmur of detainees sitting on steel benches. Miller walked her straight to the processing desk, where a seasoned intake supervisor named Sergeant Reynolds was typing away at a computer terminal. Miller confidently announced that he had a Jane Doe, an uncooperative suspected undocumented individual who was resisting and refusing to identify herself at a targeted enforcement site. Reynolds sighed, a sound born of years of dealing with vague paperwork, and looked up. He looked at the woman in the faded t-shirt and the dirt-stained pants. He looked at the handcuffs, then his eyes moved to her face. Reynolds had been in the district for 20 years. He was a regular in the federal courthouse, organizing transport and testifying in immigration proceedings. He knew the faces of the magistrates, the prosecutors, and the judges. The blood drained from Reynolds' face so rapidly he looked as though he might pass out. His hands slowly lifted from the keyboard, hovering in the air as his brain desperately tried to process the impossible reality standing in front of his desk. He looked at Miller, his voice dropping to a harsh, terrified whisper, asking what exactly he had done. Miller, oblivious to the impending doom, puffed out his chest and repeated that she was a non-compliant suspect. Reynolds stood up slowly, never taking his eyes off the woman. He bypassed the counter, walked directly up to her, and visibly swallowed hard. In a voice trembling with absolute horror, he said, "Judge Hastings, are you all right, Your Honor?" The intake room went completely, terrifyingly silent. The phone seemed to stop ringing. The typing ceased. Every officer within earshot froze. Miller felt the floor drop out from underneath him. The air was sucked from his lungs. The words Judge Hastings echoed in his mind, shattering his reality into a million jagged pieces. He looked at the woman he had just manhandled, mocked, and arrested on her own porch. She didn't smile triumphantly. There was no smug satisfaction. She simply looked at Reynolds and, in that same terrifyingly calm voice, asked the sergeant to please remove the handcuffs as they were cutting off her circulation and to kindly contact the special agent in charge of the field office, as well as her personal attorney. There was no shouting match. There was no dramatic cinematic monologue where the judge screamed at the officers. Real consequences in the legal world do not happen in loud, explosive outbursts. They happen in cold, meticulous, bureaucratic movements. The handcuffs were removed so fast, the metal clattered against the concrete floor. Reynolds ushered Judge Hastings into a private office, frantically offering her water, offering to call an ambulance, offering anything to stem the bleeding of the catastrophic liability that had just infected his building. Miller and Evans were left standing in the middle of the intake room, isolated like patients with a highly contagious disease. No one looked at them, no one spoke to them. They were told by a pale-faced watch commander to surrender their sidearms, their badges, and their credentials, and to wait in an empty interrogation room until Internal Affairs and the Department of Justice investigators arrived. The destruction of their careers was not instantaneous, but it was absolute. It was a slow, agonizing suffocation by paperwork and litigation. They were immediately placed on unpaid administrative leave. Within 48 hours, the story leaked, not to the tabloids, but through the terrifyingly efficient whispers of the legal community. Judge Hastings filed a civil rights lawsuit under Section 1983, alleging false arrest, battery, and a gross violation of her Fourth Amendment rights. In the immediate aftermath, Miller's police union attempted to shield him, citing the doctrine of qualified immunity, a legal shield that protects government officials from civil liability unless they violate clearly established statutory or constitutional rights. But this is where Miller's failure of procedural knowledge became his ultimate undoing. The law surrounding the curtilage of a home and the requirement for a warrant or probable cause is not a gray area. It is a foundational pillar of American jurisprudence, clearly established for over a century. The judge hearing the civil case, a colleague who had known Hastings for years, did not even blink before stripping Miller and Evans of their qualified immunity. The ruling was a brutal, 50-page legal dismantling of Miller's actions, noting that no reasonable officer could have possibly believed that walking onto a private porch and physically arresting a homeowner without a warrant, without consent, and without a single shred of articulable suspicion was lawful. The deposition of Thomas Miller was a masterclass in legal humiliation. Sitting in a cold conference room months later, stripped of his authority and dressed in an ill-fitting civilian suit, Miller was forced to answer for every second of that humid August afternoon. Hastings's attorney, a surgical litigator, walked him painfully through the video evidence recorded by a neighbor's security camera. The attorney forced Miller to articulate under oath exactly what probable cause he possessed at the moment his boot hit the first step of the porch. Miller stuttered. He tried to rely on the vague tip. He tried to claim she looked suspicious, but under the unforgiving light of sworn testimony, his implicit bias was laid bare. He was forced to admit that he had no legal right to demand her identification. He was forced to admit he had no legal right to step onto her porch. He was forced to admit that the arrest was born not of evidence, but of his own bruised ego and fatal assumptions. The rookie, David Evans, fared no better. His defense that he was simply following the orders of a senior officer was fundamentally rejected. The law requires officers to intervene when they witness a clear constitutional violation, even by a superior. By standing silently at the bottom of the stairs, Evans had legally ratified the illegal arrest, tying his fate irrevocably to Miller's arrogance. The fallout rippled through the agency. The civil lawsuit was settled by the government for an undisclosed, undoubtedly astronomical sum, but the professional consequences were entirely personal. The Department of Justice opened a pattern and practice investigation into the regional field office, unearthing years of similar, albeit less high-profile, constitutional violations targeting marginalized communities. The special agent in charge was forced into early retirement. Both Miller and Evans were officially terminated, their peace officer certifications permanently revoked, ensuring they could never work in law enforcement anywhere in the country ever again. Miller, facing potential federal criminal charges for the deprivation of rights under color of law, ended up declaring personal bankruptcy due to the mounting legal fees not covered by his union. The tragedy of the situation was not just the destruction of two careers, but the chilling realization of how fragile civil liberties can be when placed in the hands of those who weaponize their authority through the lens of their own bias. Judge Eleanor Hastings survived the ordeal with her dignity intact, but she carried the physical and psychological bruises of that day back to her bench. It fundamentally altered the way she scrutinized the testimony of law enforcement officers in her courtroom. It was a stark, living reminder that the Constitution is just a piece of paper, unless the people sworn to uphold it actually respect the boundaries it draws. The system did not fail because the laws were inadequate. The system failed because an officer looked at a citizen, made a biased assumption based on appearance and location, and decided that the rules of procedure did not apply. When you strip away the badge, the gun, and the authority, what is left to ensure that those in power do not abuse it? If a federal judge, armed with an encyclopedic knowledge of her constitutional rights, can be handcuffed on her own front porch in broad daylight for simply asking an officer to justify his presence, how vulnerable is the average citizen who doesn't know the exact legal definition of reasonable, articulable suspicion? We place immense trust in the hands of those who police our streets, expecting them to be the guardians of our rights, not the arbiters of our worth based on a fleeting glance. When that trust is broken, when procedure is abandoned for prejudice, it isn't just one person's rights that are violated, it is the very foundation of justice that begins to crack. In the end, the most dangerous weapon an officer carries isn't on their duty belt, it is the unchecked assumption in their mind. How safe are your rights when the person enforcing the law is the one who refuses to understand it?